Tantor Audio, a division of Recorded Books, presents Treaty Justice, the Northwest Tribes, the Boldt Decision, and the Recognition of Fishing Rights, by Charles Wilkinson. Narrated by Jason Grasl. Preface. The late 1960s and early 70s marked the beginnings of the upswelling of jobs in several areas of public interest law. I had gone to law school to practice civil rights law, but when I graduated in 1966, there were almost no public interest jobs. When that changed just a few years later, I was in private practice and began to think about the new civil rights, environmental, and other public law programs. Several people suggested that I might look at the new firm, the Native American Rights Fund, which was practicing Indian and environmental law. I applied, and on October 11, 1971, joined NARF as a staff attorney. Early on, I thanked my lucky stars. I was thrilled that my professional life would now involve working on issues that I cared about personally. Now, more than half a century later, I realized that walking through the front door that long ago day as a NARF attorney was the moment that law became technicolor for me. NARF was still in its first year. Youth and idealism spread throughout the offices. All of the dozen attorneys were less than 30 years old. They were an impressive lot. The new public interest work attracted some of the best young lawyers. NARF attorneys had already filed a number of truly major cases. Most of them, ambitious though they were, proved to be successful in whole or in part. One was a lawsuit on behalf of the tribes of Western Washington against the state of Washington, charging that the state had long violated tribal fishing rights for salmon under treaties with the United States. This is the litigation that became known as the Boldt Decision, which, along with its broad and lasting impact on law, environment, and society, is the subject of this book. The state argued that tribal fishing rights were minimal and cracked down on Indian fishermen through often violent raids, arrests, and jail time. The tribes believed that they had extensive rights under their treaties with the United States and that, among other things, Indians were entitled to as many Pacific salmon as necessary to meet their needs. I never worked on the case, but it caught my attention from the beginning. At that point, I had a rudimentary knowledge of Indian law and knew only that this was a difficult legal case, highly controversial in Washington and Oregon, where these state tribal fishing disputes were commonly referred to as fish wars. Also, I couldn't help but notice that the case revolved around fish, Pacific salmon no less. I made up my mind to follow it. After 4 years at NARF, I spent the rest of my time in law teaching, first at the University of Oregon in Eugene, and then at the University of Colorado in Boulder. I have taught Indian law, water law, and federal public land law, all oriented toward the American West. Wanting to get a sense of the region, I did plenty of book research. I also made a priority of getting out on the ground and conducting interviews with, among others, federal and corporate officials, conservation groups, ranchers and farmers, scientists, and Indian leaders and tribal members. The Indian interviews were especially fruitful. I was basically the first Indian law professor to get out in the field in Oregon, and by then the tribes were into the modern Indian sovereignty movement. Many Indian people in Oregon and Washington as well invited me out to their reservations. Delbert Frank of the Warm Springs tribe of Oregon took me down to his family fishing ground, which is still in use on the Columbia River, 4,000 feet below the rim of the Columbia River Gorge. Over the course of a full day, he explained in precise, loving detail where all of the people worked and slept, and still do, and talked at length about the cultural and religious relationships between his people and salmon. At the end of the day, we went out and pulled up a few salmon with dip nets. But Delbert's big-hearted idea was for me to get a sense of what that landscape has always meant culturally and religiously, and how it was used for thousands of years. Other people from Washington, Oregon, Northern California, and Idaho showed me around, also taking me to their sites and explaining the historical, cultural, and religious contexts. They also took me out to the dip net and long net operations on the ocean and Puget Sound. I went to 2 or 3 small dip net operations on small tributaries. The Indian people explained how the tribes have benefited from salmon as food and sometimes sales. Everywhere, including my visit with Delbert, I saw traditional canoes, spears, and apparel, as well as more modern items such as contemporary boats, rifles, and fishing gear. As the years passed by, I focused more and more on Pacific salmon. I increasingly brought them into my writing. I also took on projects involving salmon. Mediations and arbitrations between tribes and state and federal agencies, speeches, media interview requests, and giving advice on proposed legislation or settlements. Pacific salmon became my favorite animal. Then I found myself wanting to be absolutely clear on the place, the importance of the Pacific salmon. Why do people write statements like these? The definition of the Pacific Northwest is anywhere that Pacific salmon run. Salmon are the soul of the Pacific Northwest. Since the Ice Ages, this Pacific Northwest muscular fish has embodied the health and vitality of this region. Salmon are an icon. Why do Indian people and tribes often describe themselves as the salmon people? We prize oven-grilled and backyard barbecued salmon at home and in terrific salmon restaurants in Seattle, Portland, and other places in the Northwest. That is important and relevant, but it doesn't justify calling salmon the soul of the Pacific Northwest. The same is true with the joy that sport fishers feel about getting out in the open water and catching these strong, powerful, and beautiful fish. So too with the significant economic benefits to the commercial fisheries industry and the considerable economic contributions that sport fishing provides through payment of government license fees, equipment purchases, and travel, lodging, and other expenses paid by visitors. What is uniquely different and compelling about Pacific salmon is their life story. How possibly can they do what they do? There is much public film on Pacific salmon migrations, and Americans nationally have a sense of those spectacular long-distance journeys. Much better if we are able to get out to the rivers at the right time, most return salmon runs are in the fall, do our own research, or get directions from people who know the runs, we can catch sight of parts of these arresting journeys. I have been lucky to have experienced quite a lot of those moments. They are still vivid to me. Amy Cordalis and her aunt, Sue Maston, are staunch advocates for the Klamath River of northwestern California and its salmon. To them, the river and its salmon are members of their own Yurok families. Amy and Sue took me to the cliff on the north side of the mouth of the Klamath, where the river's outgoing flows hit the Pacific. The Chinook salmon were returning from their years in Alaska. It was a noisy, hyperactive scene. The salmon were jumping, diving, and playing in the ocean foam while competing with birds and each other for shrimp and small fish amid the screeching of the gulls and pelicans. We watched for a good hour. Philip Martin Sr., a gentle traditional man with detailed knowledge of his Quinault tribal history, took me to a waterfall high up on his tribe's river. We were there at the right time. The Quinault blueback sockeye salmon run was returning, and we could see the power of these fish as they charged up the furious waterfall, leaping, climbing, and swimming to conquer the imposing flow. Billy Frank Jr., Nisqually, one of the people most responsible for the Boldt Decision, allowed me to join him on a trip to spawning grounds on Muck Creek in the upper Nisqually River watershed. During spawning, all is slower and quieter because the females are releasing their eggs. Soon after, the males and females will both finish their lives. Billy and I were viewing animals that had just completed a round-trip journey of several thousand miles. Pacific salmon, so exquisite and inspiring, so rare. Based on my reading, talking with people, getting out on the water and the ground, and my own thinking, I was convinced that it is accurate to describe this grand animal by terms such as the soul of the Pacific Northwest and a muscular fish that embodies the health and vitality of this region. Another subject that I have given special attention to, starting with my time at NARF and continuing throughout my career, is American Indian tribal sovereignty. Tribal sovereignty is one of the most powerful and valuable public ideas that has ever touched my mind. I say that not just because of tribal sovereignty's legal and intellectual worth, but because it has also proved to be so invincible. The world's most powerful nation tried to terminate tribal sovereignty over the course of many generations, but could not because it meant so much to Indian people, small minority that they were, and they refused to give in. Sovereignty, the capacity to act as a government, is a technical word, but it has numerous real-world ramifications and is a living reality to Indians. To them, the reservations are islands where tribal culture and religion are protected from encroaching dominant society. Sovereignty encompasses the question of whether the law of the tribe or of the white society, in other words the state, will apply. In America, there are three sources of sovereignty: the United States, the states including their county and city subdivisions, and the Indian tribes. For more than a century after the treaties of the mid-1850s, the actual practice of tribal sovereignty declined due to aggressive, forced state and federal assimilation policies designed to eliminate the sovereignty and separatism. Modern courts, however, have found that the sovereign treaty rights are still alive. On the reservations, Tribal sovereignty is the lifeblood of the governmental authority that empowers tribes to decide on matters that really count: children, schools, family, healthcare, natural resources, their lands, and the environment. State fish and game laws such as licensing requirements, bag limits, and seasons do not apply on the reservations. The tribes are free to follow their own time-proven practices. In some regions, especially the Pacific Northwest and Great Lakes, federal treaty negotiations resulted in treaty provisions allowing fishing, hunting, and gathering rights on off-reservation lands. That means that those tribes have treaty rights beyond the reservation boundaries, allowing tribal members to take Pacific salmon and other marine resources. In 2013, Billy Frank Jr., chairman of the Northwest Indian Fisheries Commission, asked me if I would be willing to write a comprehensive book on the Boldt Decision, such a monumental event for the Northwest tribes, Indian country generally, and beyond. Billy explained that many tribal members had not even been born when the decision was announced. Other tribal members lacked a context for the decision. Also, the general public in the Northwest and nationally should have a reasonable and accessible book presenting the Boldt Decision. The Fisheries Commission provided a generous grant for my research assistance, travel, and other expenses related to the book. I would write independently and would receive no honoraria, stipend, or other payments to me personally. By that time, I had written quite a lot about natural resources and tribes in the American West and nationally. I regularly referred to the Boldt Decision in my work. Like Billy and the Northwest Indian Fisheries Commission, and doubtless many others, I also believed that the Boldt Decision deserved a full treatment. With its 50th anniversary coming up, this was a good time to do it. I enthusiastically began work on it. Treaty Justice is my book about this historic and sweeping judicial ruling. The Boldt Decision, handed down by a federal district court in 1974, announced tribal, state, and federal rights to harvest and environmentally manage salmon and other marine fisheries in the Pacific Northwest. Judge George Boldt's opinion was affirmed nearly completely by the United States Supreme Court. When people, including myself, refer to the body of law contained in those two opinions, they often refer to them collectively as the Boldt Decision, probably because the Supreme Court relied so heavily on Judge Boldt's opinion. These court opinions rest in part on constitutional provisions addressing treaties, congressional authority, state police power, tribal sovereignty, and the supreme law of the land. This book presents those in a straightforward, non-legalistic way. Importantly, such constitutional terms often take shape in a context of history, culture, economics, and the actual workings of state and tribal governments. The Boldt Decision, then, did decide constitutional provisions, but very much on the judges' minds were salmon, tribal sovereignty and culture, community participation, the economics of salmon harvesting, tribal and non-tribal fishing practices, and the performances and effectiveness of state, tribal, and federal fisheries offices. The Boldt Decision has had an exceptionally broad reach into the future. This book explains the effects of that decision on people, governments, and the environment in Washington, Indian country, other states, the nation, and even other countries as well. We can hope and expect that Judge Boldt's earnest and wise words will continue. 1. Fury on the Puyallup River. The police were all up on the bridge with rifles, and we could see their rifles kicking, and you could feel the bullets going by. There was nowhere you could go. Washington's Puyallup River, such a fine breeding ground for Pacific salmon, originates in the glacial waters of Mount Rainier and, gathering cool water from tributaries, runs north and northwest through mountain meadows and forests of cedar, fir, and hemlock before flowing into Puget Sound. The Puyallup Riverbank near the Pacific Highway Bridge in Tacoma is calm now, but in the summer of 1970, it provided the site for one of the most terrifying police raids during the violent fish wars of the 1960s and 70s. Indian fishermen believed they were exercising long-standing rights under treaties with the United States to fish for salmon in their traditional ways. The state officers believed that the fishermen were violating valuable state conservation laws. Whether measured in dollars, recreational enjoyment, or Indian culture, Pacific salmon were a mainstay of the Pacific Northwest. In the summer of 1970, with chaotic conflicts regularly erupting on most of northwestern Washington's rivers, events came to a head. Early in August, to support the fishermen down on the river, hundreds of committed Indian people established an encampment on the banks of the Puyallup River. On August 13, tribal leaders announced that state officers were not welcome and that the tribes themselves would police Indian fishing at the Puyallup encampment. Early September marked the time when the big Chinook, also called king, salmon, the most prized of the Pacific salmon, made their summer run up the full-bodied currents of the Puyallup River to spawn. State police scouted the encampment area by boat early in the morning of September 9. Sure enough, the Chinook were charging up the river and the Indian fishermen were busily working their nets. Indians at the encampment fired 4 warning shots near the police boat. Indian people, their supporters, and curious citizens were streaming into the area. Everyone knew this would be the day. A few hours later, the police, hundreds of them, attacked. Their rifle shots pierced the air and the stench of tear gas hung over the encampment. Ramona Bennett, chairman of the Puyallup tribe and the highest tribal officer at the encampment, lived the violence that day, recalling that the police were all up on the bridge with rifles and we could see their rifles kicking. You could feel the bullets going by. There was nowhere you could go. I was so scared that my legs were stiff. It was like that Frankenstein walk you do when you are absolutely terrified. The police prevailed. They arrested more than 60 people, including 5 children. They confiscated the fishermen's catch, nets, and traditional carved cedar canoes. They dragged the fishermen up the rough, rocky riverbanks, making good use of their fists and billy clubs, and jailed them with bail of up to $3,500. Then they bulldozed the teepees, wood shelters, and fire pits of the summer-long encampment. Almost miraculously, no one was killed or suffered long-term physical injuries. The fish wars were a long time in the making. The Indian treaties of the mid-1850s in the Pacific Northwest had supposedly settled the pressing issue of Indian fishing rights. The arriving settlers coveted the salmon for food and economic opportunity. The tribes were salmon people, and for them the fish were as important as the land. Territorial Governor Isaac Stevens, tough, smart, and bent on acquiring as many acres of Indian land as possible, pushed hard and successfully to locate the tribes on small reservations. Tribal leaders, however, refused to sign off on the land transfers unless the United States agreed to guarantee tribes the right to fish on the homelands that the tribes transferred to the United States. The government acceded, and each of the 5 Stevens treaties promised tribes the right of taking fish at their traditional fishing grounds in common with the citizens of the territory. While the reservations were only small remnants of the tribe's traditional lands, these off-reservation rights covered most rivers and marine waters in western Washington. The settlers, believing that Indians should be limited to their reservations, were hostile to these off-reservation rights from the beginning. They forced native people off their longtime fishing grounds, cut their nets, and stole or damaged their canoes. When tempers flared, local judges were quick to back up the settlers by jailing the Indian fishermen. When Washington became a state in 1889, the legislature passed laws restricting off-reservation Indian fishing. The stresses heightened into the 20th century. The salmon runs declined due to logging, dam construction, and steadily increasing commercial and sport fishing by non-Indians drawn to the green Pacific Northwest. By the post-World War II era, lines had hardened. The state expanded and intensified its crackdown on Indian fishing with brutal arrests, confiscations of catch and gear including canoes, and jail time with high bail. The tribes claimed the sovereign right to regulate native fishing under the terms of their treaties with the United States. Under the U.S. Constitution, treaties were the supreme law of the land, meaning that treaty promises overrode inconsistent state laws and actions. State enforcement officers would have none of it. They and their government superiors claimed that the Indian fishermen were renegades and poachers who were thumbing their noses at important state wildlife conservation laws. Every Indian fisherman felt the pressure. Some quit fishing entirely. Many eschewed the daylight hours and limited themselves to dark time fishing. One early morning in December 1945, Billy Frank Jr., Nisqually fisherman and perhaps the most luminous figure in the long line of events from treaty time to the present, suffered the first of his many arrests, confiscations, and jailings. He was 14 years old at the time. Just as the pace of arrests multiplied, so did the tribe's resistance. By the mid-1960s, the tribes, learning from the tactics of the civil rights movement, were conducting well-publicized fish-ins at the Puyallup, Nisqually, Green, and White Rivers to demonstrate their determination and build public support. By then, the national commitment to civil rights was helping the tribes. The state law enforcement agencies, however, were benefiting from the civil rights conflicts in a very different way. In 1965, 20 years after his first arrest, Billy Frank Jr. and his brother-in-law, Al Bridges, were fishing on the Nisqually River in a traditional cedar canoe on a placid autumn afternoon. All of a sudden, out of a slough on the far side of the river, a massive high-speed motorboat was charging at them full throttle. This boat was coming at me and Bridges like a bat out of hell. We turned upstream and tried to run them into another net, but we never made it. Those bastards rammed us at full speed and knocked us clean over. We had our hip boots on, and it was harder than hell to swim. I honestly thought I was going to drown. We finally got to shore and other guys were waiting for us. "Stop or we'll shoot." At the beginning, these guys had no idea how to run a boat on this river, but they got real serious about this. And this was the time of Selma. There was a lot of unrest in the nation. Congress had funded some big law enforcement programs, and they got all kinds of training and riot gear, shields, helmets, everything. And they got fancy new boats. These guys had a budget. This was a war. On September 8, 1970, Stan Pitkin, the hard-charging young United States Attorney for Western Washington, walked downstairs in the federal courthouse in Seattle to the clerk's office and filed the complaint in United States v. Washington. The chief federal legal officer for Western Washington, Pitkin had no clear idea of how the case would unfold. A Republican appointed by President Nixon, he passionately believed in the rightness of the cause of his clients, 20 Indian tribes in the Puget Sound Olympic Peninsula area. He knew about the fish wars, everyone did. As the months wore on, Washington looked more and more like Mississippi and Alabama. In addition to enforcing tribal rights, the United States Attorney earnestly wanted to use the legal system to help end the ugliness on the rivers and in the streets. Pitkin and the lawyers who intervened in the litigation on behalf of the tribes could not project how the case would turn out because the legal terrain was so uncertain. Federal Indian law was an ancient body of law, protective of Indian treaties, and federal attorneys specializing in Indian law were generally optimistic about this case, but the field had lain mostly dormant for generations. Besides, the United States and the tribes were seeking extraordinary and unprecedented relief. Pitkin's original complaint called for the court to allocate a fair share of the off-reservation salmon runs to the tribes. In time, the Justice Department and tribal lawyers agreed that the tribal allocation should be quantified at 50% of the off-reservation fisheries. The accepted principles for interpreting the meaning of words in Indian treaties were that courts should give heavy weight to the intent of the tribes and should construe ambiguous treaty terms in the tribes' favor. The legal team became satisfied that verbal statements made at the treaty negotiations, Isaac Stevens, for example, told the tribal negotiators that "this paper secures your fish," coupled with court decisions dating back to leading opinions handed down by Chief Justice John Marshall in the 1830s, supported a 50% tribal share. Washington state fish and game officials, while acknowledging that the physical conflicts on the rivers caused some political problems, announced that the 50% claim was ridiculous. Tribal fishermen were taking only 2 to 5% of the salmon, depending on the tribe. The commercial fishing industry was taking more than 90%. Requiring a 50% share for the tribes would mean a wholesale reworking of a regional economy that was, after all, commonly described at that time as timber, salmon, and boeing. Sport fishers accounted for a small part of the annual harvest, but river and ocean sport fishing was enjoyed by a large and passionate segment of the population. The federal tribal 50% position was counterintuitive to most of the general public. Was the 50% allocation fair? Was it realistic? Could a judge do it? Could the citizenry accept it? Could the political system? 50% of the salmon to 1% of the population? After all, the treaties said only that the tribes could take salmon in common with the non-Indian citizens. Still, unlikely as it might have seemed, Judge Boldt's final opinion of over 200 pages found for the tribes on virtually every issue, large and small. His main ruling was that the treaties, in guaranteeing to the tribes the right to fish in common with the citizens of the territory, meant that the tribes were entitled to harvest 50% of the fisheries after accounting for conservation of the runs. Judge Boldt handed down his opinion on February 12, 1974, deliberately choosing Abraham Lincoln's birthday. Judge George Boldt's ruling, affirmed by the U.S. Supreme Court in 1979, is a landmark in the American civil rights movement. It belongs in the same company as Brown v. Board of Education and a select few other court cases in terms of bringing justice to dispossessed peoples. Like those opinions, the Boldt decision's ramifications are many and still felt today. And, like those cases, the Boldt decision vividly displays the brilliance and worth of the American system of justice and the moral and tangible benefits it can achieve at its heights. 2. The salmon people. Those Fraser River salmon are like blood in your veins. It's part of you. When Stan Pitkin filed United States v. Washington in 1970, no one could have known or even imagined all that it would accomplish. How did that come about? What drove Judge Boldt and the Supreme Court justices to find that the tribes reserved in the treaties a full 1/2 of the entire fishery in northwestern Washington, a result so bold, so disruptive of a settled, powerful economic and social regime? On first read, the treaties were opaque. The tribes had the right to fish in common with the citizens of the territory. The ultimate answers to these questions, though, are not found in the law books. Under long-established American law, judges do not read treaties in isolation. Words in treaties can be understood only in light of the entire context. At its heart, this case about law was a case about history. What brought the United States and the tribes to the treaty proceedings in the 1850s? What did the United States want to gain, and what did the tribes want to preserve? What did the United States intend? What did the tribes intend? What were the historical circumstances? The most critical matter in this exploration of life in the Pacific Northwest in the mid-1800s and before was an understanding of the kind and level of reliance that those tribal societies placed on salmon. The United States, the state of Washington, the tribes, and outside scholars, all steadily prodded by Judge Boldt to do their best work, produced a voluminous amount of information. What emerged was a comprehensive historical portrait that was informative, rich, and notably different from the impressions held by most Americans of ancient indigenous peoples. The 20 Boldt case area tribes have always been known as salmon people. What does that mean, especially in the aboriginal, pre-contact times before the treaties were negotiated? How important were the salmon to those people? All the tribal stories and anthropological and historical research make it clear that these ongoing fish were pervasive in their lives. Salmon was the staple in their diets. Salmon carried great cultural and spiritual meaning. The tribes established mature and robust economies with salmon as the main driver. Internally, salmon was the principal measure of social status, which depended upon how many material goods, but especially salmon, were distributed to the needy. Beyond the villages, salmon were essential in commercial trade relations that extended up and down the coast and across the Cascades to the east. This elaborate regime required huge amounts of the big fish, and the tribes annually achieved prodigious harvests, several times larger than the takes by all participants in the salmon fishery combined, including the largest commercial vessels in the 21st century. And there was something simpler, a treasured constant for the people. They loved going out with their nets, spears, and weirs into the bracingly fresh air, onto the open seas and the rivers that flowed through the thick, wet, and misty green forests that so distinguished their homelands. They had the satisfaction of fishing in the same way, in the same places as their ancestors had fished for thousands of years. Some 10,000 years ago, after the glaciers from the Wisconsin glaciation melted and released their grip on the landscape, ancestors of the 20 tribes in the Boldt case area began to settle in what is now northwestern Washington and southwestern British Columbia. Eventually, this area became one of the most populated by natives in North America, and it is easy to see why it was so attractive. The North Pacific Current, like the Gulf Stream in the North Atlantic, brings in moderate temperatures while the Cascade Mountains contain the western warm air and create a barrier against cold air from the plains to the east. Leaving aside the high peaks of the Cascade and Olympic ranges, the land was mostly heavily wooded, usually right down to the water. Given the regular rains and the marine location, water was everywhere: creeks, streams, rivers, bays, and wide open stretches of the Salish Sea in the Pacific Ocean. The thick, big tree forests had disadvantages. They allowed little overland travel. Elk and deer, grazing animals, did not use the deep timbered areas, although both, along with mountain goats and bears, could be found around lightly forested places and those flat prairies that interrupted the woods. But the forests gave much to the native people. These towering, inspiring mixed stands of Douglas fir, spruce, hemlock, yellow cedar, and, beloved by the people most of all, red cedar, gave great trunk lengths for canoes, lumber for homes, firewood, and bark, branches, and foliage for fishing nets, clothing, healing, and other uses. And the behemoths that together let in little light and rose up out of sight offered another extraordinary gift: the ground-level understory. With all the moisture, good growing temperatures, shade, still air, and soft soils enriched by fallen giants of millennia past, the forest floors were a spongy wet mass of organic matter. Ferns, fungi, skunk cabbage, salal.
Sample complete. Ready to continue?